Hi, this is Curt, and welcome to another edition of Fire Law Roundup. That may very well be.
Okay, let's come a little bit. Yeah, let's come a little bit back to the coast, and we'll go to California. I'm going to explain what I understand. Maybe you know something more. I don't really understand this well. There's a lot missing from this, from the allegations we know, right? So here's what happened. We have a fire captain. He was out on disability. He returns to disability, but the department has refused to allow him to return to full duty and placed him on administrative leave. He claims, and again, this is a suit, so allegations once again, but he claims that this is because they perceive that he has a disability. The reason he uses that phrase, perceive they have a disability, is because that's also prohibited by the ADA, the Americans with Disabilities Act. You can't discriminate against somebody based on an actual disability or a perceived disability. So he's saying there's a disability that's perceived. Now that's going to be my question: is what's the perceived disability? He claims
it's a seizure.
Seizure disorder.
It's a seizure disorder. Yeah.
Right.
Yeah.
He's guessing, though, I think, and we know why he's guessing that. But in any event, he gets cleared by his own physician, which may not be an ADA issue, but it's certainly the family medical leave entitles you to go to your own physician for FMLA purposes. On the other hand, he had to go to the department's doctor, and the department's doctor then creates some restrictions for him based on a perception of a possible seizure disorder. And they basically say, you've got to get so much sleep on duty, and because you can't get that sleep, you can't be in the fire truck. You have to be on the desk because we can't assure you getting sleep. And he comes back and says that is a attack to a perceived disability, and it bears no rational, my words, not his, bears no rational relation to the perceived disability anyway, which I think is what's being left out. Is maybe they're saying if you do have a seizure disorder that you increase the risk of having a seizure if you don't get enough sleep. I'm guessing, but I who knows. In any event, the plaintiff claims that this is completely bogus. This work restriction is all just a ruse to keep him out, that no other captain has had the same sleeping requirement, which may be true, but on the other hand, they may not have a seizure disorder either. So in any event, the lawsuit just says that they continue to wrongly perceive the plaintiff as disabled. They put him on administrative leave. They need to return him, and they haven't. Now, I want to point out one thing. No, he hasn't quit, which I think is very important. Don't quit. I keep saying this, but
he must have been listening to you.
Don't quit.
I know you've said that numerous times before. He must have been listening. So
there, I'll take it. In any event, so I have some questions like: did he have a seizure disorder? Who said he had? What was he out for previously? Was it a seizure? Because 1910, the fire 29 CFR 1910 126 of the fire brigade standard says that if you have a seizure or a seizure history, you might be prohibited from being an interior firefighter, right? It's unless you have notes from doctors and blah blah blah. So having a seizure is right in federal law, or seizure history is right in federal regulations, that it could be an acceptable excuse to keep you out of interior firefighting. But Curt, what's your thoughts?
Well, I think there's a couple of procedural questions that I got, and one of them, what it appears is the department routinely allowed the individual member's doctor to return them to full duty, and which I think many fire departments do. They don't want to have their own doctor, even though 1500 and it says that you should have your own doctor. But at any rate, what it seems to allege is that historically the department has always allowed members to put themselves back through their own provider. And so I think one lesson here is for fire departments: what do you do in a situation like this? Because where you become aware that someone's had a condition, and let's assume he did have a seizure or whatever it was that precipitated him being off, became known to other members. And I've been in this situation where people come to me as a chief and they're like, hey, so-and-so had a seizure and he shouldn't be on the truck, and I don't feel safe with him or her, and you need to do something. And if you've routinely allowed them to go on their own medical recommendation, their own doctor's recommendation to return to full duty. Now you're in a situation where, how do I justify sending him to our doctor if we've never done that before? So you want to have thought through that and have a system in place that allows you the ability, based on whatever reasonable cause or whatever it is, to have someone go, in addition to their own doctor, go to your own doctor. But if you don't have that, then it looks like, because of a perceived disability, you sent him to this other doctor. And now you've got a possible disparate treatment claim right here, just based on that. So without even going further, it looks like maybe we got a problem. In terms of firefighter safety, and I think sometimes we've got to put the laws are good, we should follow the laws the greatest, but above all, our concern is the safety of our employees. And I think that's probably the tack that the department took here. It's a challenge. What exactly do you do? If you have a system, then you just follow the system. When you don't have a system and you're kind of making it up, it looks like discrimination. And it looks like this department was trying to do the right thing, assuming that there's nothing in the background that we are not aware of. It looks like they were trying to do the right thing, but they weren't prepared for it, and maybe they took some steps that were on account of this person's perceived disability.
Yeah, my take on this is right along with yours, that we do often send people to their own physician, and there is a good reason for that, at least one. But I am finding, as you've definitely found, that most fire departments have horrible physical examination, physical and mental fitness abilities, and they don't say what objective findings you can or can't have in order to be an interior firefighter, or in the volunteer world, a driver, fire police, whatever. And there needs to be a physical and mental fitness job description for every single job. Now, there also, as you well know, NFPA 1582, right? We need to 1582, 1583. We need to have we need to have something like the category A and category B conditions. And I know they're admission conditions, but I also use them, the way I do it, as I make everything a category B once you've been hired, meaning that if you have a condition that you develop after you're hired, you can still work there if the doctor says you can do the job. But those category A and Bs, or they all become Bs, at least provide an objective physician saying, if you have this condition, how does it affect? Right now, here's my problem. Let's take blood thinners. NFPA talks about you can't be on blood thinners, right? Because, as any fire service physician will tell you, if you have a crush injury and you're bleeding, you will die. So not good to be on blood thinners. However, a normal doctor may not be thinking of that. A normal doctor may not think of the chance for crush injury. Maybe they say, oh, I'm just a driver and all I do is drive the fire truck, so doctor, return me. And most of the times, you all know this is true, listeners, that when you go to your doctor, when you're allowed to, and your doctor says, oh, yeah, can you do that? Can you lift 150 pounds? Can you bend over? Can you climb a ladder? Can you wear 60 pounds of gear? You're like, oh, yeah, no problem. Right? There's no real evaluation, and the doctors have no idea. So here's what I am guessing, totally guessing, has happened. It's one thing to say, look, you broke your arm, and your own doctor gets to say, I've removed the cast and the arm is healed. Okay, that's one thing. But it's a different standard saying you having had, and I don't know if this is what it was, you having had a seizure affects your ability to do the job in accordance with our standards. That is rightfully your own fire department physician's role, if your policy says it, to evaluate. So saying you're healed from a condition, broken arm, whatever, is one thing, right? Let their own doctor say they're healed. Whether they then have a condition or limitation that affects them to do the job, to me, that should be the fire department's physician who makes that, and that's got to be in policy. If that wasn't policy, they're fine. If not, they're trying to explain to the judge, well, we don't have a policy, but we kind of have a practice. That's my take on this. They wanted their physician to say this is unsafe.
Yeah, we'll see. It's one of those cases. We'll see where it goes, but I think the lesson here for departments that don't have a formal procedure, policy procedure in this regard is to kind of think this through. What are you going to do if you're getting complaints? And I've been there where people come to me and they're saying, I don't feel safe. They had this happen. They had that happen. They're not, I don't care what their doctor says, they're a liability to me. They can't rescue me, and there's no way I'm going to be able to rescue them, and yada, yada.
Yep.
So.
Agree. And I think unions don't always push this, because unions like, oh, we want to go to our own doctor, until the unions want to, kind of keep one of their own out. Then they're like, oh, no, come to our doctor.
And we don't want to me, the department doctor should not be used as a weapon by the department administration. It should be someone who's going to actually have the best interests of the firefighter, the patient at heart. And I'm sure they're all going to say they do, but we know that I've seen it in the past where they go for an IME, and the doctor that's doing the independent medical exam wants to know, how do you want this to come out? Before they see the patient. So
yeah, and I'll tell you the way I do this, just to finish this up, I guess the way I do this in policies is I say, look, it's your own doctor, if they choose, should be able to say whether you still have a condition, whether you're healed, what your limits are. That's for your own physician to diagnose your present medical or physical or mental condition, right? And they say you do or do not have this condition, limit, disease, whatever. It is for the fire service physician, in my best practice world, it's for the fire service physician to say, I'm accepting as true what your independent physician says as to your condition, still has it, doesn't have it, limitations, whatever. And based on what that physician says, here's how it plays out in the fire department, right? So for example, you have a seizure disorder, and the doctor says you have a seizure disorder, which is rare, but possible, and it could be exacerbated by certain things. Fine. It's not up to the fire service physician to evaluate the diagnosis, right? But it is up to the fire service physician to say whether that, based on that diagnosis, this person can meet the objective physical fitness and physical requirements. Would you agree with that?
Yeah, I think so. And to me, I'm more of a consensus kind of person, no matter what I'm doing, whether it's chairing a committee or whatever it may be, leadership. But I think if we can get the two doctors in a conference call, I don't need to know what they talk about. I just need to know we got two doctors, they both agree. And the two of you get in a Zoom room, have that conversation, and don't come out until you give us a yes, he can work, or no, he can't, and let them work that out between them. And if they can't, we'll bring in a third doc to sort of mediate. But I think this is a medical decision. It's not a lawyer decision. It's not a fire chief decision. It's a medical decision that should be made by the doctors. So.
And physical and mental fitness ability should never be used to disguise hatred, discipline, right? If it's a pretext, that's one thing. And look, that's what they're arguing. It's a pretext. That's what everybody always argues. And the question is it a pretext or not? Or am I being unfairly treated differently than somebody else? Those are your two points.